Just because a source doesn't have exactly what you're looking for, doesn't mean there's nothing you can take out of it either. Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranayaka. The bane of many students across many jurisdictions when it comes to law is understanding questions and formulating or articulating comprehensive responses. Oftentimes, my fast track and masterclass students tell me that the most difficult aspect of a law degree is, on the one hand, doing the necessary research, and on the other hand, understanding what an examiner wants from them and then putting it down on paper. If you're interested in learning how best to break down both essay and problem or fact pattern questions and then articulating comprehensive first-class level responses, I highly recommend having a look at the workshop series available on the online law school platform, which you can access through the links in the description below or through the pop-up that will appear on this video right now. One fundamental aspect that I often tell my fast track and masterclass students to help them navigate, so to speak, a response that is not only rewarding in terms of their academic prowess and what an examiner would be looking for, but also something that they can carry with them, as much as you who's watching this particular YouTube video going into a proficient legal career, is to not just take any aspect on face value. What do I mean by this? Essentially, when you're presented with a problem, when you're presented with an issue in order to break down and articulate a response for, oftentimes what students tend to do is try and find a case, an article, an academic opinion that goes in line with that thinking. More often than not, from an examiner's standpoint, what they would want to do, rather than giving you the exact clear-cut response which you can, as a cookie cutter, so to speak, find from a case or an article, they'd actually prefer to see how argumentative and innovative you would be with the resources that are available to you. Oftentimes, examiners will actually try to give you a fact pattern or a scenario or an essay that goes completely distinct or separate, contrasting itself from a case or a principle that has already been established. There's one word that I want you to incorporate and inculcate into your vocabulary in terms of how you formulate academic responses. Distinguishing. What do I mean by this? You would have often heard of a similar terminology when it comes to judges who hold decisions, so to speak, in relation to any case that is presented to them from an appellate perspective. You would see some cases being applied, some cases being followed, some cases being considered, and others, quite interestingly, being distinguished. A case being distinguished is essentially to suggest that it's not overruling a decision of another judge or another court, but essentially saying that the facts or the scenario or even the fundamental issue in the case that is being presently heard is somewhat different and distinct, and the court is willing or opting to go a different direction. This is exactly what I want you to think of when you're articulating a response, and the sources that you have taken on board or that you've researched doesn't necessarily go in line with your own opinion or your own argument. This is not to say that the source has to be disregarded entirely. Rather, look at the fact pattern, look at the question presented to you, see what's missing, and that component which is missing, consider it as the flip side of the coin. Look at the sources that you have as research and determine if it is in fact not going in the same line of thinking as that of the fact pattern. Distinguish it. Consider it as an argumentative opportunity to show an examiner that you appreciate the decision and the principle, and that you've identified a component that is distinct or different from that which the judges would have identified in the case that you are citing. Doing this not only shows your examiner that you have read the case on the one hand, read the facts on the other, understood that there is a mismatch or a gap in the application, and chosen to go a different path with your own opinion and arguments. Your examiner will reward you for this thinking. The reason why this video was felt important by me is because oftentimes when I read my fast track and masterclass students' answers and the responses that they provide for questions both in essay format as well as fact pattern, I tend to see a generic format of trying to fit a round peg in a square hole, rather than understanding that it's not a round peg or a square hole, but a vast opportunity, a sea of opportunities to explore. So the next time that you look at a problem scenario or an essay question, don't think of trying to just find something that matches the scenario. Think of looking at situations which might not match and what opportunities may present itself for argument. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.